If you have a spouse, a fiancé, or a family member waiting to come to the United States, then the year 2026 has brought some changes you absolutely need to know about. The rules surrounding marriage green cards and family-based immigrant visas have shifted in ways that are affecting thousands of applicants right now. From new documentation standards at USCIS, which stands for U.S. Citizenship and Immigration Services, to longer interview requirements and increased scrutiny at consulates abroad, the path to bringing your loved one to America looks different than it did just a year ago. And here is the most important thing to understand right at the start. If you are already in the process, if you have already filed your I-130 petition, your application has not been thrown out. But that does not mean you are unaffected. There are real changes happening that could impact your timeline, your documentation, and even your interview experience. We are going to walk through all of it today, including who is affected, what has actually changed, and what you should be doing right now to protect your case. If you are interested in this topic and liking this video, please stay tuned until the end of the video. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. The landscape of marriage-based immigration has always been one of the most scrutinized areas of the United States immigration system. In 2026, that scrutiny has intensified. Reports suggest that USCIS has quietly updated its internal review guidelines for I-130 petitions, which is the foundational form used to establish the qualifying relationship between a U.S. citizen or lawful permanent resident and their foreign national spouse. The I-130, officially called the Petition for Alien Relative, is the first step in virtually every family-based green card case. What makes this year different is the level of documentation now expected to prove a bona fide, meaning genuine, marriage. In a recent development, immigration legal analysts have noted that adjudicators are looking more closely at the totality of evidence in marriage-based cases. This means that a marriage certificate alone, or even a collection of photos, is no longer considered sufficient in many cases. Officers reviewing these petitions are now expected to evaluate financial ties, shared living arrangements, communication records, and evidence of a shared life together over time. The administration has made clear that preventing fraudulent marriage petitions is a priority, and that message has filtered down into how frontline officers are approaching these cases. Here is what you need to know if you are currently filing or planning to file an I-130. The categories of people affected by these updated standards are broad. If you are a U.S. citizen petitioning for your spouse abroad, your case will likely go through consular processing, and your spouse will be applying for what is known as an IR1 visa, which stands for immediate relative, or a CR1 visa, which is a conditional resident visa for marriages under 2 years old. If you are filing for a spouse who is already inside the United States, your case may be eligible for adjustment of status, meaning your spouse applies for their green card without leaving the country. Both pathways are now under heightened review. For petitioners filing for spouses of lawful permanent residents rather than U.S. citizens, the process runs through the F2A visa category, which is part of the family preference system. Unlike the immediate relative category, F2A visas are subject to annual numerical caps, and wait times in this category have grown considerably. According to current visa bulletin data, F2A applicants from some countries are looking at waits that stretch beyond what many families anticipated. This situation might feel incredibly frustrating, especially for couples who have been separated for months or even years. Let us take a closer look at what the documentation changes actually mean in practical terms. Immigration experts note that USCIS is recommending that applicants submit what the agency describes as secondary evidence of a bona fide marriage in addition to the standard primary documents. This includes things like joint bank account statements going back at least 12 months, lease agreements or mortgage documents showing both spouses at the same address, beneficiary designations on life insurance or retirement accounts, medical records listing your spouse as an emergency contact, and a personal statement from both spouses describing how they met, how the relationship developed, and what their day-to-day life together looks like. Legal analysts suggest that this personal statement, while not a new requirement, is now being read far more carefully by adjudicators than it was in previous years. Beyond the petition stage, there are significant changes happening at the interview level as well. For cases processed through U.S. embassies and consulates overseas, the DS-260 immigrant visa application and the accompanying interview have always been the final gatekeeping step. Reports suggest that consular officers have been instructed to conduct more probing interviews in 2026, particularly for couples who have spent limited time together in person, couples who met online, and couples with significant age differences. This does not mean these relationships are invalid. Many completely legitimate marriages will still face this added scrutiny, which is why preparation is more critical than ever. The K-1 fiancé visa, which allows a foreign national to enter the United States to marry their U.S. citizen partner, is also experiencing the effects of these policy shifts. Processing times for the K-1 have extended in 2026, with advocacy groups reporting average wait times at many embassies now running between 14 and 16 months from the time the I-129F petition is filed to the time the visa is issued. For couples hoping to plan a wedding, this extended timeline is creating real emotional and financial strain. Despite these challenges, it is important to say clearly that the marriage-based green card process has not been shut down. It has not been paused. Approvals are still happening every single day. What has changed is the standard of proof and the time required to meet that standard. The administration claims that these measures are necessary to protect the integrity of the immigration system. Critics and advocacy groups warn that the increased scrutiny disproportionately burdens couples in long-distance relationships, international couples, and those from lower-income households who may not have joint financial accounts or shared property. While there have been some modifications to how interviews are conducted, one important piece of information is that couples should be absolutely consistent in the information they provide. The I-130 petition, the DS-260 application, and everything stated during the interview must all align. Inconsistencies, even minor ones, have become far more likely to trigger requests for additional evidence, known as RFEs, or in more serious situations, an administrative processing hold on the case. In addition to these changes, public charge considerations remain a factor for green card applicants. The I-944 Declaration of Self-Sufficiency, while its use has fluctuated with different administrations, and the Affidavit of Support, Form Y-864, continue to be critical documents. Officers want to see that the sponsoring spouse in the United States meets the financial threshold to support their incoming partner without relying on government assistance. So, what should you do right now? If you have not yet filed your I-130, start building your evidence file today. Do not wait until the form is ready to start gathering your documentation. If your case is already filed and pending, consider consulting with an immigration attorney to review your evidence package before your interview is scheduled. If your interview has already been scheduled, practice answering questions about your relationship thoroughly and honestly. Both spouses should be prepared to discuss the same details about how they met, when key milestones in the relationship happened, and what their plans are once the green card is approved. To summarize, 2026 has brought meaningful shifts to the marriage green card process. The core pathway remains intact, but the bar for demonstrating a genuine relationship has been raised. Processing times for certain categories have lengthened, and interviews are being conducted with greater scrutiny. These changes affect everyone from newly married couples filing for the first time to long-separated families waiting in the F2A backlog. However, with thorough preparation, strong documentation, and a clear understanding of what officers are looking for, successful outcomes remain IAHEAL. That is all we have for this bulletin. The USA State Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we will see you in the next video. If you haven't subscribed to our channel, please subscribe to the USA State Channel for more U.S. immigration update videos.